Chairman Van Drew, Ranking Member Crockett, Ranking Member Raskin, Mr. Johnson, thank you for inviting me here today. First, a confession. I've never been to Delaney Hall, and I've never toured the facility to assess any of the allegations that have been made about it. That said, for more than 8 years, including 6 as a staffer for this committee, I exercised oversight jurisdiction over ICE detention facilities and visited many. In addition, I served for an additional 8 years as an immigration judge at the York County Prison in Pennsylvania, which contracted with ICE for detention space. I walked the facility, I ate in the dining hall, and I worked out in the weight room. Consequently, I am intimately familiar with how ICE detains aliens and the national detention standards under which it operates. As the Third Circuit described it last year, the elephant in the room today is the fact that state and local officials in New Jersey oppose immigration detention in the Garden State. First, the legislature enacted AB 5207 to prohibit entities there from contracting with ICE to run detention facilities. The Third Circuit subsequently concluded that this law, as applied to ICE's Elizabeth detention facility, was an improper attempt to, quote, dictate the manner in which the federal immigration function is carried out, close quote, in a violation of the doctrine of intergovernmental immunity. Such efforts have continued, however, and shortly after GEO announced it would be opening Delaney Hall for ICE detention, the mayor vowed to padlock, quote, unquote, the facility, and then the city sued GEO, complaining Delaney Hall didn't receive proper permits and local officials had been denied access. GEO was requested the case be dismissed because ICE wasn't added as a party, but in any event, it appears city inspectors have subsequently been allowed access. Nonetheless, in June, the state sued GEO, contending health inspectors had been denied, quote, full access, close quote, to Delaney Hall when they arrived in response to conditions there. In response, DOJ complained about the politicization of the issue while also contending ICE has, quote, authorized access to the facility for a reasonable and appropriate inspection pursuant to the state's written request, close quote. Both cases are ongoing, but key constitutional federal doctrines, as I laid out in my written testimony, will govern the court's resolution of each. Most notable is what I talked about before, intergovernmental immunity, a principle under which state attempts to regulate the federal government directly or state actions that discriminate against the U.S. government or those with whom it deals are invalid. While those doctrines may invalidate state action, they cannot and should not restrict federal oversight, including and especially congressional oversight. Such oversight, as I explained at the outset, was my stock in trade for more than 8 years. But both my bosses and I were, some of whom are surrounding us today, were always conscious of performing it in such a way so as not to impede the very functions that we were investigating. That was particularly true when it came to immigration detention. The security of facilities and the safety of the officers and detainees therein was always paramount, and I was always willing to comply with reasonable restrictions imposed on me when touring the facilities, and I continue to believe, with due respect, that is the appropriate policy. Skepticism, of course, is the best policy when conducting oversight, and there is always a danger that what Congress is being told isn't the full truth. There are, however, numerous safeguards built into the system to ensure that problems aren't hidden and the legislative branch is not deceived. By my count, 5 congressional committees oversee ICE detention, to say nothing of the DHS Inspector General, other internal watchdogs, Office of Professional Responsibility, etc., the Government Accountability Office, the media, and internal whistleblowers. Moreover, ICE's detention standards are contractual and as enforceable as any contract, and the agency expects performance. I understand that many oppose immigration detention, but I'll also note that the first law passed this Congress was the Lake and Riley Act, which mandated detention and empowered the states to sue to ensure it occurs. You can understand why ICE officers in New Jersey and elsewhere feel like they're getting whipsawed by this body. Finally, even if local politicians successfully forced ICE detention out of New Jersey, that doesn't mean aliens would be released. Instead, they'd be sent far away from their families and their lawyers, and that would not make their cases or their plights any easier. Again, I thank you for your time, and I look forward to your questions, and I yield back.